here to talk to you today about domestic violence cases. So one of the things that people have a lot of questions about is the role and involvement of the alleged victim in a domestic violence case. I often get calls from victims indicating that they would like to drop the charges. Well, the problem is in Colorado, the victim cannot drop the charges. Unfortunately, simply because you call the prosecuting attorney or the detective and say you do not want to move forward does not mean that that individual is obligated to heed your request. Ultimately, it is law enforcement's decision as to whether or not to make an arrest, and once the case is sent to the prosecuting attorney, it is their decision as to whether or not to pursue the charges. However, you can still have an important role in the case. You can advocate for a particular outcome. You can do other things to help. If you were not personally served to appear in the case, in many circumstances that will result in dismissal of the charges. However, there are often aggressive efforts to get you under service, so your not wanting to be involved or simply indicating that you will not show up in court is often not going to be enough to resolve the charges in the defendant's favor. The best course of action is for the individual charged with the domestic violence crime to secure a criminal defense attorney to guide him through the process. And should it be the case that the alleged victim is willing to cooperate and would like a favorable outcome, the defense attorney can reach out to that individual and confer with them. Obviously, they can't tell them what to do, but there would be nothing prohibiting them from reaching out and ascertaining their position. So, if you would like the charges dropped, understand that there are still ways that you can help, even though they are perhaps not the ways that you would like. And one of the most important things to remember, oftentimes when people are arrested for domestic violence, the other party goes to the initial bond hearing thinking that that is the best way to help. That is in fact often the worst way to help, because if you appear at the initial bond hearing, they will almost always give you a subpoena to testify in the proceedings and to appear at subsequent proceedings. So it is actually better that you not appear at that court date, because ultimately once you were served, then you are tied into the case, and if you fail to appear for a court date you were served for, you can actually be held in contempt of court. If you have any questions about a domestic violence case here in Colorado, feel free to contact me and I'd be happy to address your questions. Thank you. Goodbye.